If you hold a green card or live in the United States on a visa, the word breaking should not be ignored today. A new federal law has quietly shifted how compliance is measured, and it is aimed directly at lawful immigrants who assume their status is secure. This is not a mass cancellation, and it is not a dramatic raid. It is something more subtle, more effective, and far easier to miss. The danger is not what the law says loudly, but what it expects silently from people who are not paying attention, right now across federal systems nationwide. Most people believe legal status protects them automatically, but this law redefines protection as ongoing participation. Congress approved changes that strengthen data sharing, verification, and monitoring across agencies that handle immigration records. When systems synchronize, silence no longer equals safety. Doing nothing becomes a signal. This law does not accuse anyone of wrongdoing. Instead, it creates conditions where oversight increases quietly, triggered by missing confirmations, outdated information, or delayed responses. Those triggers rarely produce instant penalties. They produce reviews, delays, and questions that arrive later, usually when timing matters most. That is how pressure builds without notice for visa holders. Green card and visa holders are the primary audience of this shift because they interact with the most systems. Employment authorization, travel permissions, renewals, address updates, and benefit eligibility all generate data points. This law aligns those points and checks them continuously. Small inconsistencies that once went unnoticed can now surface automatically. A missed update here, a delayed response there, and suddenly a routine process slows down. The system does not argue, it waits. And while it waits, people lose time, options, and flexibility they assumed were guaranteed under previous rules. Protections frameworks and enforcement habits nationwide today suddenly gone. This law was not designed to feel aggressive. It was designed to feel administrative. That distinction matters because administrative changes rarely trigger urgency. They feel optional, technical, and easy to postpone. But this rule turns postponement into risk. When registration, verification, or confirmation windows exist, missing them becomes meaningful. The enforcement is not loud, but it is consistent. Consistency favors those who act early and disadvantages those who wait. That imbalance is intentional. It accelerates compliance without confrontation and shifts responsibility onto individuals quietly through automated systems, timelines, databases, audits, workflows, reviews, and cross-checks. Nationwide, now active everywhere today immediately. The people most exposed are not those already in trouble. They are those who believe stability protects them. Long-term residents, professionals, students, families, and workers who have followed the rules for years are often the least alert to change. This law leverages that comfort. It assumes inattention and builds consequences around it. Not punishment, but friction. Friction delays approvals, interrupts plans, and creates stress without ever announcing blame. By the time awareness arrives, the system has already adjusted expectations and recorded the gap across immigration databases, case files, timelines, queues, workflows, officers, supervisors, audits, metrics, reports, nationwide, silently, continuously, today. Congress framed the law around efficiency, security, and modernization. Those words sound neutral, even reassuring. But efficiency reduces tolerance for exceptions. Security increases scrutiny. Modernization removes human discretion. Together, they reshape enforcement without changing headlines. Green card and visa holders feel this first because their status depends on alignment across systems. When alignment breaks, everything slows. Travel pauses. Employment renewals stall. Family petitions wait. None of this requires wrongdoing. It only requires misalignment between what the system expects and what it receives from individuals during routine checks, updates, renewals, verifications, audits, integrations, migrations, synchronizations, reports, flags, alerts, reviews, processes, nationwide. This is why the law feels sudden only in hindsight. It does not arrive as a single moment. It arrives as a pattern. Each interaction becomes slightly heavier, slightly slower, slightly more demanding. People sense something changed but cannot name it. That uncertainty creates anxiety. Anxiety leads to mistakes. Mistakes invite more scrutiny. This feedback loop is not accidental. It is how compliance systems mature. They reward consistency and penalize delay without ever raising their voice while maintaining procedural neutrality, administrative distance, technical language, standardized notices, silent deadlines, automated consequences, structured follow-ups, escalating thresholds, internal scoring, risk models, enforcement logic. The title breaking matters because awareness changes outcomes. People who understand this law early experience it as a checklist. People who learn late experience it as a problem. That difference has nothing to do with innocence or intent. It is about timing. Systems reward those who align before enforcement becomes routine. Once routines harden, flexibility disappears. Appeals exist, but they are slow. Corrections exist, but they are expensive. Prevention remains the cheapest option, and prevention depends entirely on attention to details, deadlines, updates, confirmations, registrations, records, notices, compliance, calendars, reminders, systems, portals, workflows, requirements, expectations, oversight, mechanisms, enforcement, cycles, now. This law also signals direction. It tells us where immigration enforcement is moving next. Toward automation, toward continuous verification, toward systems that watch without asking. Green card and visa holders are the testing ground because their data already flows through multiple channels. What works here expands elsewhere. That is why early compliance matters beyond individual cases. It shapes how strict the system becomes overall. High compliance stabilizes enforcement. Low compliance invites tightening through regulatory adjustments, thresholds, audits, penalties, scrutiny, timelines, oversight, funding, staffing, metrics, targets, priorities, algorithms, scoring, policies, guidance, interpretations, practices, norms, expectations, standards, models, designs, nationwide, gradually, inevitably. The purpose of this section is not fear, it is clarity. Clarity allows preparation. Preparation restores control. This law targets green card and visa holders not to punish, but to standardize. Standardization removes ambiguity. Ambiguity once protected people. Now it exposes them. Understanding that shift is the first step toward staying ahead of it. In the next section, we will examine exactly how this law operates in practice and where people misjudge its impact most often so they can avoid delays, reviews, disruptions, costs, stress, uncertainty, friction, scrutiny, penalties, consequences, setbacks, interruptions, surprises, notices, gaps, flags, holds, pauses, denials, later. The second phase of this law becomes visible when you look at how everyday immigration processes now interact with one another. Under the old framework, each process largely stood on its own. A green card renewal lived in one lane. A visa extension lived in another. Employment authorization, travel documents, address updates, and benefit eligibility each followed separate timelines with limited cross-checking. That separation created breathing room. Delays in one area did not always spill into another. The new law collapses those lanes into a shared system where information is continuously compared, synchronized, and evaluated. This change matters because it redefines what compliance looks like in practice. Compliance is no longer just meeting the requirements of a single application. It is maintaining alignment across multiple systems at the same time. When one record lags behind, it can now affect everything else. A delayed address update may surface during a work authorization review. A pending visa extension may slow a travel document. A missing confirmation may pause a family petition. None of these outcomes require a violation. They require only inconsistency. Green card and visa holders feel this shift most acutely because their legal presence depends on ongoing interaction with federal systems. Citizens may go years without engaging immigration infrastructure. Non-citizens do not have that luxury. Their status is active, conditional, and periodically reviewed. This law intensifies that reality by increasing the frequency and depth of review without increasing visibility or communication at the individual level. One of the most important mechanisms introduced by the law is expanded data validation. Agencies are no longer satisfied that information exists. They now validate whether it remains current. That distinction is subtle but powerful. An address that was correct 2 years ago may now be treated as unverified. An employer relationship that was documented previously may require reconfirmation. A status that has not changed may still need affirmation. The system is designed to reduce assumptions and increase certainty, but the cost of that certainty is more work for individuals. Another critical element is timing. The law does not operate on a single deadline. It introduces rolling expectations. Different actions trigger different checks. Some are periodic. Others are event-driven. The complexity makes it harder for people to know when they are fully compliant. Many assume that completing one requirement covers everything. Under the new system, that assumption is risky. Compliance is layered, not linear. This is where many people misjudge the law's impact. They look for a clear moment when everything changes. They expect an announcement, a cutoff date, or a single form that resolves the issue. Instead, the law creates a background condition. Systems expect confirmation. When confirmation does not arrive, nothing dramatic happens immediately. The absence is logged. Over time, that log influences outcomes. For visa holders, this often surfaces during extensions or changes of status. Processing times increase. Requests for evidence become more common. Officers rely more heavily on system-generated alerts. When alerts appear, discretion narrows. Officers do not ignore system signals easily. They are trained to follow them. That training is reinforced by audits and performance metrics tied to compliance enforcement. Green card holders experience the impact differently, but just as significantly. Travel becomes more sensitive to record alignment. Employment verification relies more heavily on real-time status checks. Applications that once felt routine now include additional steps. Again, none of this implies wrongdoing. It implies caution on the system's part and burden on the individuals. The law also changes how mistakes are handled. Under older models, minor errors could often be corrected informally. A missing document could be provided later. A clarification could resolve confusion. The new system is less forgiving because automation reduces flexibility. Once a record is flagged, it enters a workflow. Exiting that workflow requires documentation, time, and sometimes legal assistance. What once took days can now take months. Another overlooked consequence is psychological. When processes slow unexpectedly, people lose confidence. They question their understanding. They worry about unseen problems. That stress leads to rushed decisions. Rushed decisions create errors. Errors trigger further scrutiny. The cycle feeds itself. The law does not create this anxiety intentionally, but it enables it by removing the informal buffers people relied on. It is important to understand that this shift aligns with broader government trends. Automation, standardization, and data integration are not unique to immigration. They are happening across tax systems, benefits, licensing, and enforcement. Immigration simply feels more intense because the stakes are higher. Status touches work, family, mobility, and security all at once. The law's designers understand this. They also understand that most people comply when requirements are clear and consequences are indirect. By embedding enforcement into routine processes, the law achieves compliance without confrontation. People adjust because friction is uncomfortable, not because punishment is immediate. For individuals, the lesson is practical. The law rewards consistency. It penalizes delay. It favors those who engage early and regularly. Waiting for problems to appear is no longer a viable strategy. Problems appear quietly and compound before they announce themselves. This is also why misinformation spreads so easily around changes like this. People search for dramatic explanations. They expect extreme outcomes. In reality, the impact is incremental. It is felt in slower timelines, extra steps, and reduced flexibility. Those effects are harder to explain but more likely to be experienced. Understanding how the law operates in practice allows people to respond intelligently. It allows them to treat compliance as maintenance rather than crisis. That mindset shift is essential. The law does not target individuals. It targets misalignment. Staying aligned is now an active process, not a passive one. The next section will focus on what preparation actually looks like in this environment and why acting early changes outcomes so dramatically. This is where awareness becomes advantage and where small actions prevent large disruptions. The final phase of this law is where preparation becomes the dividing line between stability and disruption. By the time enforcement feels visible, most of the outcomes are already determined by what happened earlier. Systems do not suddenly decide to scrutinize a case. They respond to histories. Histories are built quietly through patterns of engagement, confirmation, and response. That is why the most important action under this law happens before any notice is ever sent. Preparation begins with understanding that compliance is no longer episodic. It is continuous. Green card and visa holders who treat compliance as something that only matters during renewals or applications are operating under outdated assumptions. The new environment expects alignment at all times. That does not mean constant action, but it does mean constant accuracy. Records must match. Information must be current. Confirmations must be completed when required. Silence is no longer neutral. The first practical step is awareness. Knowing which obligations apply to your status, which systems hold your information, and which actions trigger reviews changes everything. People who understand the landscape make fewer mistakes because they are not surprised by requests or timelines. They anticipate them. Anticipation removes urgency. Urgency creates errors. Errors attract attention. Avoiding that cycle is the core advantage of preparation. The second step is consistency. Updating information in one system but not another creates misalignment. Misalignment is what automated checks detect most efficiently. Addresses, employment details, travel history, and status confirmations must be treated as a single profile rather than separate tasks. The law assumes that if information exists, it should match everywhere. When it does not, the system does not ask why. It flags the case and moves it into review. The third step is timing. Completing requirements early is not just convenient, it is strategic. Early action allows room for correction. Late action compresses options. If a problem is discovered close to a deadline, stress increases and flexibility decreases. The system does not slow down because someone is under pressure. It follows its schedule. People who move ahead of deadlines control the pace. People who wait surrender it. Another overlooked aspect of preparation is documentation. Keeping records organized, accessible, and consistent matters more now than ever. Requests for evidence are more common, and response windows are often short. Searching for documents under pressure leads to incomplete submissions. Incomplete submissions extend reviews. Extended reviews increase exposure to additional checks. Preparation interrupts that chain before it starts. There is also a mental shift required. Many people believe that good intentions protect them. They do not. Systems evaluate completion, not effort. The law does not care whether a requirement was missed accidentally or intentionally. It records whether it was met. Accepting that reality allows people to act pragmatically instead of emotionally. Emotion clouds judgment. Pragmatism reduces risk. Contrast again becomes clear here. Prepared individuals experience the law as administrative. Unprepared individuals experience it as invasive. The rule is the same. The experience is not. That difference is entirely within individual control, but only before enforcement becomes routine. Once routines harden, choices narrow. It is also important to understand that preparation is not a one-time project. It is an ongoing habit. Systems will continue evolving, requirements will be refined, thresholds may change. Those who build habits of engagement adapt easily. Those who rely on past experience struggle. Immigration compliance is moving in the same direction as other regulated areas. Continuous verification is becoming normal. The law's long-term impact will depend partly on how people respond now. High compliance stabilizes systems. Low compliance justifies stricter enforcement. Individuals cannot control policy, but collectively they influence how aggressive enforcement becomes. Early compliance sends a signal. Widespread delay sends another. For green card and visa holders, the takeaway is simple, but not easy. Do not assume stability means safety. Stability now requires participation. Participation means attention. Attention prevents surprises. Surprises are what turn routine processes into crises. This law does not eliminate opportunity. It raises the cost of inattention. People who adapt will continue their lives with minimal disruption. People who do not will encounter friction that feels personal but is actually procedural. Understanding that distinction removes fear and restores agency. In the end, this moment is less about restriction and more about transition. The system is transitioning to a model that values data alignment over discretion. Those who transition with it remain comfortable. Those who resist or ignore it feel pressure. The choice is not ideological. It is practical. Preparation is not about doing more. It is about doing things earlier, more consistently, and with better awareness. That is the difference between being managed by the system and managing your relationship with it. Under this new law, that difference defines outcomes.